Because what Bhagavad Gita teaches me is verse 2, Shloka 24, Bhagavad Gita says, Achodhyayam, Adahyayam, Akledyo Shosya Evacha, Nityaha, Sarvagataha, Sthanur, Achaloyam Sanatanaha. The Vedas spoke mostly about dharma and karma, duty and action, and not about adhikara or right. That Ponmudi, she lists out certain duties. She says, Indru purantarudal enthalai kadane, Sandro nakkudal thandaikku kadane, Velvadithu koduttal kollarkku kadane, Kaliru erindu payarudal kaalaikku kadane. In fact, the period between 1946 to 48 is historically important for three reasons.
Sir, having taken over as the chairperson of the National Human Rights Commission, now what exactly are the challenges that you face?
That there are two challenges. We can follow the same steps as a civil court can follow to enforce attendance. Therefore, it is not a toothless tiger in areas relating to investigation and inquiry.
It's a great pleasure to have the chairperson of the National Human Rights Commission and former Supreme Court Justice, Shri V Ramasubramanian, in our mess for this 13th edition of the ThinkEdu Conclave. There are certain people who are called the lawyer of the lawyers, but Justice Ramasubramanian is fondly referred to by the judges in the bar, in the bench, judges in the bench as judge of the judges. Most of the judges, if they have some complicated issues or complicated decisions to be taken, their first instinct is to call up Justice Ramasubramanian and consult him on that. In fact, many of the landmark judgments that have come up in the last 3-4 years have, in fact, the background of Justice Ramasubramanian's wisdom. Now, in this conclave, he has been associated not only with, he was introduced as a justice. More than that, he is a trilingual scholar who is good in Sanskrit and very good in English. More than that, exceptionally good in Tamil. And his lectures and his participation in Tamil literary events are something which people look forward to come, to visit, to hear. And Dinamani and the New Indian Express group, we have a special association with him. He gave Tamil language 25 new words. See, every language needs to get itself richer with the changing world. You get new things coming up and you need new words. Otherwise, the language will become stale. And he ran a series in Dinamani called Solvetai, in which Solvetai means hunting for words. And in that, 25 words have been given to Tamil language by him. And all the scholars in Tamil, they all tell me, whenever I go there, whenever I meet them, they pester me. Why don't you ask him to continue that? We need more new words. So such is his vast and wide repertoire and his knowledge that we have him in our midst. And now over to him. It is for him to take the
Thank you, Mr. Vaidyanathan. When I was invited to inaugurate this 13th edition of ThinkEdu Conclave, I was a little worried because 13 is supposed to be an unlucky number. Therefore, to inaugurate the 13th edition and to ensure that it is successful and you don't have to take the blame if something goes wrong, I had to offer special prayers before I came here. But as Mr. Vaidyanathan pointed out, I have been associated with Dinamani for a very long time. Apart from writing center page articles in Dinamani, as he mentioned, I ran a column called Solvetai, Hunting for Words, on the same lines as Barbara Wallroff ran a column called Word Court and Word Fugitives for the Atlantic Times. There is a small correction. Mr. Vaidyanathan mentioned that we created 25. Actually, I ran the column for 52 weeks, 1 full year. And it was so successful that my successor was none else than the former Vice Chancellor of Tamil University. He had to continue what I had left. And apart from these 52 weeks of Solvetai, I also wrote a series of articles on what lies beyond the realm of science, Ariviyalukku Appal. So those 27 articles became such a great hit that one of the Swamijis of a mutt used to call me and used to tell me that whenever this column appeared every week, he used to give a lecture to his disciples on the same day evening. So I was assured of an occupation post-retirement from whatever he said. I thought I will start one ashram after my retirement, but probably time is there for this to materialize. The topic that has been assigned to me for discussion is balancing the scales, rights, duties, and the Indian soul. But I have a small problem with one portion of this topic, and that portion is the words Indian soul. Whatever I know, there can never be an Indian soul and a foreign soul. Because what Bhagavad Gita teaches me is verse 2, Shloka 24, Bhagavad Gita says, Achodhyayam, Adahyayam, Akledyo Shosya Yevacha, Nityaha, Sarvagataha, Sthanur, Achaloyam Sanatanaha. Swami Vivekananda translated this verse to mean, this soul, the sword cannot cut, nor the spear pierce, the fire cannot burn, nor water melt. It is indestructible, omnipresent is this soul, therefore weep not for it, is what Bhagavad Gita says. If the soul is omnipresent, then that soul is common for India and for people everywhere in the world. Maybe what the organizers wanted to mean was balancing the scales, rights, duties, and probably the word should have been Indian spirit and not the Indian soul. If you look at the history of societies, I think all societies, once upon a time, were only duty-conscious societies rather than rights-conscious societies. Take, for instance, the Indian society. The Vedas spoke mostly about dharma and karma, duty and action, and not about adhikara or right. We have had Dharma Shastras and Dharma Sutras, even Artha Shastra, but not Adhikara Sutra and Adhikara Shastra. Probably the first ever convocation address is to be found in the Sikshavalli portion of the Taittiriya Upanishad. After completing education, the student takes leave, the disciple takes leave of his guru, the teacher, and he asks for the final word. What is the end of education? The teacher sets the tone. He says, now that you have completed education, please remember Satyam Vada, Dharmam Chara, Swadhyaya Anma Pramadaha, Acharyaya Priyam Dharmahritya Prajatantum Mavyavachetsi, Satyanna Pramaditavyam, Dharmanna Pramaditavyam, Kushalanna Pramaditavyam, Bhutyaina Pramaditavyam, Swadhyaya Pravachanabhyamna Pramaditavyam. Look at the meaning of the words. The teacher says, speak the truth, practice dharma, do not neglect the study of the Vedas. Having brought to the teacher the gift desired by him, Guru Dakshina, enter the householder's life. This is what the teacher says. And see that the line of progeny is not cut off. Probably that is what Tamil Nadu and Andhra are now advocating. Do not swear from truth. Do not swear from dharma. The next two lines are extremely important because we have conceptually a misunderstanding of what the Vedas say. Next two lines, the teacher says, do not neglect personal welfare, do not neglect prosperity. Do not neglect personal welfare, do not neglect prosperity, is what the teacher says. Therefore, what was taught to a student when he completed education was to be conscious of his duties. Even the great Tamil culture, which we now hail to have had the Stone Age started 5,300 years ago, it enlisted only duties and not rights. The Purananuru, Sangam literature, had a woman poet by name Ponmudi. That Ponmudi, she lists out certain duties. She says, Yindru Purantarudal Yentalai Kadane, Sandro Nakudal Tandaikku Kadane, Velvadithu Koduttal Kollarkku Kadane, Kaliru Erindu Payardal Kalaikku Kadane. So a woman poet of the Sangam age, she lists out duties. Even Moses gave only 10 commandments and not 10 rights. Therefore, historically, societies appear to have been duty conscious much more than rights conscious. But what happened was, over a period of time, probably in the 20th century, the course of history took a different turn. If you look at what happened before the 19th century, the first modern constitution connecting rights and duties of individuals was the French Constitution of the year 1795. The declaration of the rights and duties of man and citizen in this constitution included 9 articles listing out duties of individuals, containing most importantly the duty to respect laws, mentioned 4 times in 9 articles. The list also establishes horizontal duties such as, look at this, the Declaration of 1795 lists out duties in 9 articles, which include duty to be a good son, good father, good brother, good friend, and good husband. That is why we don't want to get married now. One of the duties straight away we can abolish. The next came the Spanish Constitution of the year 1812. It was called the Cadiz Constitution, which was only short-lived. But this was the first constitution in the Hispanic world to feature duties alongside rights. This constitution balanced newly established individual rights and traditional deference to society and the state and the nation of Spaniards. In the Americas also, duties re-emerged, most prominently in the Mexican Constitution of 1917. Some of these are individual vertical duties of the Mexican citizen to receive military training, but the Constitution also included horizontal duties, such as, for example, the duty to educate one's own children. The Mexican Constitution of the year 1917 was the forerunner of all the following Latin American constitutions of the 20th century. The Mexican Constitution highlights the right to education in its long and detailed third article. In the 1929, the American Institute of International Law, a group of legal scholars and diplomats with members from the United States and Latin America, published what is called the Declaration of the International Rights of Man. The first 3 articles of the declaration specified the duties of states to protect their citizens' rights to life, liberty, property, religious freedom, and language. The American Law Institute declared that they believed rights were pious aspirations unless accompanied by clear statements of states' duties. This American Declaration of Rights and Duties of Man, approved at the 9th International Conference of American States at Bogota, it's called Bogota Declaration, Colombia in 1948, contained in Chapter 1 a catalog of civil and political rights as well as economic, social, and cultural rights. As a corollary, the second chapter of this American Declaration, Bogota Declaration, contained a list of corresponding duties. The preamble to this American Declaration stated that the fulfillment of duty by each individual is a prerequisite to the rights of all, and that the rights and duties are interrelated in every social and political activity of man. The declaration said, while rights exalt individual liberty, duties express the dignity of that liberty. This is what the Bogota Declaration said in 1948. In fact, the period between 1946 to 48 is historically important for 3 reasons. Number 1, it was during this period, 1946 to 48, that this American Bogota Declaration came, and it was during this period that the Universal Declaration of Human Rights was prepared by the United Nations Commission, and third, the Constitution of India was also under preparation. It was at that same time. Therefore, 1946 to 48, 3 historical events happened. One was the Bogota Declaration, another was that Universal Declaration of Human Rights, and the third was the preparation of our Constitution. When the original draft was presented to the United Nations, the member states, it contained a list of drafts. The drafting committee of the Universal Declaration of Human Rights enlisted certain duties to be incorporated. But unfortunately, there were objections by member states. Therefore, the final draft of the Universal Declaration of Human Rights contains only one article making a mention about duties, and it is Article 29. And this Article 29 says, everyone has duties to the community, in which alone the free and full development of his personality is possible. The draft had to undergo this change from its original position because of opposition from the global south. In fact, Mr. Malik of Lebanon was the first person to lodge his objections, and then it was followed by China and Philippines. Subsequently, the chairperson of the drafting committee agreed that we cannot turn a document which talks about human rights into a document of human duties, and that is the reason why the final draft approved, which is now available in its final form, mentions about duty only in one article, namely Article 29. This failure to include duties in the UDHR has had a cascading effect in all the subsequent treaties on rights, such as International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. These covenants also carefully avoid any reference to duties. When the Constitution of India was adopted, what happened was there were no provisions regarding fundamental duties. Part 3 contained a list of fundamental rights. Part 4 contained the directive principles of state policy. But after 25 years of the adoption of the Constitution, in the year 1976, as all of you know, the 42nd Amendment to the Constitution came, wherein Article 51 capital A was inserted as Part 4 capital A, listing out the fundamental duties. The original 42nd Amendment contained only 10 duties as fundamental duties. By 2002, the 86th Amendment included a 11th duty, namely the right to put children into education, that actually got transformed into a fundamental right later on. Therefore, the debate, rights versus duties, is an ongoing debate. As I pointed out at the beginning of my speech, traditionally all societies focused on duties, but in the course of history, we took a small detour. We carefully avoided speaking about duties, and now this debate has again regained momentum. In fact, increasing the awareness of the public about their duties to fellow human beings has become the focus of the talk worldwide. People have carefully started avoiding mentioning the word duty, and the word responsibility has been replaced instead of the word duty. Therefore, how we balance our rights vis-a-vis our duties, because without our respecting the rights of others, without imbibing upon ourselves the duty to respect the rights of others, I think our own rights will be put in jeopardy. With these few words, I take pleasure in inaugurating this two-day conclave. Thank you very much.
Sir, having taken over as the chairperson of the National Human Rights Commission, now what exactly are the challenges that you face?
In fact, in my first interaction with the media after I took over as the chairperson of the National Human Rights Commission, I said that there are two challenges. One is that the accreditation of the National Human Rights Commission with the Global Alliance for National Human Rights Institutions, GANRI, has been deferred for the past 2 years.
Is there any particular reason for it?
No, the reason was that the very setup of the National Human Rights Commission, according to them, is not in tune with the Paris Principles of 1993. But there is a fundamental, these are issues which we have to address, but there is, I think personally, there is a fundamental flaw in their argument. The argument of the Global Alliance is that the establishment of the NHRC is not in tune with the Paris Principles. But I think if you have to assess an institution and give accreditation, you must assess its performance and not its DNA. If you assess the performance of the NHRC and say that it is not up to the standard, we don't give you accreditation, I agree. But if you say that there is a congenital deformity in the way you are born, then I think NHRC, it's not an accreditation of NHRC, but it is an accreditation of the government and not the NHRC. Anyway, we are now trying to address those issues. That is the first challenge. Second challenge is, India is a hugely diverse country. We have people practicing more than 8 major religions of the world. We are divided by 1,640 castes and communities. We speak more than 22 official languages and about 700 languages and dialects, different ethnicities. We don't agree with each other. And I wonder how we all promoted a joint family system when we don't agree with anything on. We don't even agree on the menu on the table, but we have lived together. Therefore, in such a country, the challenges to the enforcement of human rights come not merely from the state actors, but also from the non-state actors. When for instance, you write a book, somebody doesn't like the book. You produce a film, some people don't like a film. You have your freedom of expression, they have their freedom of expression to come and protest. They don't allow the screening of the film. They don't allow the release of the book. When the interests of two ideologically opposite groups clash, then the challenge is not exactly by the state actors, but the challenge is by the non-state actors. Necessarily, the state has to intervene. When the state intervenes, how much they go and where do they stop is the question where we measure, how it ultimately turns out to be. These are, according to me, some of the challenges.
But general perception is NHRC is a toothless tiger, so you don't have judicial power with it. So is it an impediment to enforce the human right?
There are 3 issues actually. In fact, the judgment of the Madras High Court, a full bench judgment of the Madras High Court said that there are ways and methods by which NHRC can be saved from the allegation of being a toothless tiger. There are 3 things. National Human Rights Commission has got the powers of inquiry, powers of investigation, and powers to make recommendations. Insofar as power to make recommendations is concerned, the Act calls the final order passed by the Commission as a recommendation. But insofar as the power to investigate and power to conduct an inquiry is concerned, the Act says that the NHRC will have all the National Human Rights Commission or the State Human Rights Commissions will have the powers of a civil court. Therefore, we have the power to summon and enforce the attendance of witnesses. We have power to, record evidence. If somebody does not turn up, we can follow the same steps as a civil court can follow to enforce attendance. Therefore, it is not a toothless tiger in areas relating to investigation and inquiry. The allegation that is toothless tiger corresponds to the final orders passed where it is only a recommendation. But the full bench of the Madras High Court in 2021 read the word recommendation to mean an order. Therefore, by judicial precedent, some kind of denture has been given to NHRC. Now we have probably the artificial tooth instead of artificial intelligence, as Mr. Prabhuchala mentioned.
Thank you, sir. No, thank you very much for inaugurating and enlightening us on National Human Rights Commission as well. Thank you very much.